second panel discussion for the day, which is Innovation, Technology, and Promulgation of International Dispute Resolution Procedure. To discuss this, I would like to welcome on stage Ms. Anku Khanna, Managing Partner, TheAttorneys Corporate Law Consultant, LLP. Ms. Pallavi Shroff, Managing Partner and National Practice Head, Dispute Resolution at Shardul, Amarchand, Mangaldas & Co. Asaf Göktuğ AKDERE, General Counsel, Chief Legal Officer at Havelsan. Ladies and gentlemen, please join your hand together.
Good afternoon, everybody. So we are here presenting the topic on innovation and technology in international arbitration. And I have a very eminent panel with me sitting here on the dais today. So let me introduce both of our panelists. Asaf is the Chief Legal Officer and Company Secretariat of Havelsan, which is an establishment of Turkish Armed Forces Foundation and one of the leading software and defense companies in Turkey. He served as a judge for 10 years, both in different first instance civil courts and Ministry of Justice Directorate General for International Law and Foreign Affairs. After serving as a sitting judge, he mostly dealt with concluding international agreements, drafts, supervising judicial authorities, mutual legal assistance matters as Central Authority of Turkey. He also represents the ministry at the meetings of international organizations and networks, for instances EJN, Eurojust, UNCHR, UNODC, Hague Conference Private International Law. He has double major economy and law, has double LLMs on international civil and commercial law from Leiden University and Ankara University. He has several published articles to his credit. He is also an arbitrator and Insurance Arbitrator Commission and serves as mediator, Ministry of Justice. He is a member of Aerospace and Defense Industries Association of Europe and board member of Lawyers Club. Our second panelist, Pallavi Shroff, is the managing partner of the firm, heads the dispute resolution practice, and is also the chief mentor for the firm's competition law practice. She has pioneered advanced technology adoption and digital transformation within the firm for enhancing its client service delivery. With over 40 years of experience, Pallavi's expertise spans across dispute resolution, corporate restructuring, competition law, white-collar crime, and investigation. Pallavi frequently advises, represents, and supports clients on high-stake litigation and arbitration matters. She regularly appears before the Supreme Court of India and various high courts. Pallavi is an alternate member, India, at the International Chamber of Commerce Court of Arbitration, Paris. Pallavi was a member of the Raghavan Committee set up by the government for legislating the competition law in India and has been a key member of the panel responsible for amendments in the Competition Bill 2022. She has engaged in various advocacy initiatives in relation to the competition law since its inception. So just to set the tone of today's topic, we all know that technology is spread across all sectors and legal industry is not left behind. So technological development is taking place across and legal industry is also embraced and is not lagging behind. With pandemic spreading across the globe, courts in many countries move to online mode. Court proceedings, hearings, and other legal procedures are conducted online via Zoom, Microsoft Teams, or other applications. Now that legal world has embraced technology, the key question is, how can technology assist parties in resolving their disputes? So my first question to Pallavi, is there a need to use technology in arbitration? And I would like you to throw some light on the kind of technology that is being used today.
Thank you, Anku. I think today's day and age, use of technology is inevitable. So two different perspectives let me give you. One, a little more theoretical perspective, why we should be using technology, and one is a more practical approach. On a theoretical approach, let me put it this way. Arbitration is all meant to be a speedy and a cost-effective dispute resolution method. In India and in several other countries, we've seen arbitrations going on for several years. That's not the whole purpose of an arbitration. So if there is a way in which we can do an expeditious disposal of a dispute, I think that's the way to go forward. Use of technology certainly helps to move forward more expeditiously and perhaps in a more cost-effective manner, because when 3 arbitrators meet, how often can they meet? What are the costs involved for everybody traveling across from different jurisdictions? These are all things that add up at the end of the day. And instead of being a very effective alternate dispute resolution method, it tends to become very costly. So I think that is certainly one theoretical way in why we should be adopting technology. Let me give you a simple example. When we all go to Singapore, or from India, when we go to Singapore or London for arbitration, you have the verbatim recording agencies who record every word of what is spoken. But if you were doing a cross-examination in India, you'll have the arbitrator, you pose the question, the arbitrator will paraphrase it, a steno will type it, then it will be shown on a screen, and then the witness answers, and very often the witness wants to change his answer after reading it. So can you imagine the process, that time that is taken for just one question? It's literally 5 minutes for one question. You don't get anything done in one day. So given all these delays that happen, use of technology, and today we don't need even those recording agencies. Most of the platforms that we use all have recording facilities. So I think the use of technology is actually completely inevitable. On a more practical basis, as Anku has said, given that pandemic happened, we couldn't meet physically for arbitration purposes. Initially, I think a lot of arbitrations got postponed, but when we realized pandemic was here to stay, all of us recalibrated, including the arbitrators and mediators, and were happy to do a virtual hearing. So I think that was the fastest way of adoption of technology.
Yeah. Right. So now over to Asaf. I would like you to now tell us what role each of these technology play in conduct of arbitration. Does it affect the speed of arbitration? And how does stakeholders use it very commonly?
Yes. Before I start, it's an honor for me to stand before you today, and I also heard that there are more than 300 online attendees to this session. So I will try to be fast, and I will be showing that some of the slides for you. I'm not trying to convince you how fruitful to use an international technology in international arbitration proceedings, because the surveys that are taken by ICC is already showing us this. Use of technology, you can see the percentages, I believe. 93% of the respondents agree already on the efficiency and cost effectiveness that just Mrs. Pallavi mentioned us. And after the pandemic, you can see before the pandemic, it's only 2% that saying that we are really making the online hearings and virtual cases. But now the expectation is rising to 95% or more. And now you can see those slides. I need to show you 2018 and then 2021. Especially at the last one, you can see the percentages is really, the people they are saying never is really decreasing. So that's a fascinating proportion to know that the people are already convinced by how fruitful to use international, to use ITs. And what are the technologies, as you ask, is the first one, which already mentioned, is virtual hearings and video conferencing. Without further ado, I can tell the second one is file case management systems. This is also something we need to mention, because the challenges in here is the data privacy and the hacking problems. you submit the evidences online via those platforms, but the emails that you send the arbitrators can be hacked. So to just avoid this issue, you need to use those platforms, and every international arbitration center is aware of that. So they use these, all of them are using those case management systems. So I highly recommend to use those management systems, and for you, you just need to know the e-discovery system before using them. So e-discovery tools are basically allow parties efficiently collect, review, and analyze vast amount of data. So this is not only streamlines the process, but also improves the accuracy and comprehensiveness of the evidences. So that's why this is also another survey. E-discovery tools are the first one that people who attend these processes at the first place. So I recommend they use e-discovery tools before to avoid those handle with the privacy issues and both the hacking problems that you may face. And also the second technology is, of course, artificial intelligence. The use of artificial intelligence and machine learning algorithms has significantly enhanced the efficiency and accuracy of international arbitration, I believe. But it's really nice to use. You can use, especially the machine learning services, on the automatic translation services. During the virtual hearings, the using of translators bots are important because they are translating what party says and transcribe it at the same time, so that you can see and correct it like you are in a court. So with those FTPs, they exist as both free online services in international arbitration centers and enterprise-grade services. So I need to warn you on that stage that suitability of free services, owing to their potential inaccurate translations and user agreements, developers also can access to any content uploaded there. So you are already compromising confidentiality and security of the content. Because we are operating in defense and software sector, the confidentiality is really important for us. So we are trying to avoid those concerns, and I highly recommend to do so for you. And also, blockchain offers secure and immutable record keeping for you, but I have some doubts about the enforceability, which maybe we can discuss later. And the last but not least, the blockchain arbitration we are heading to. We are using blockchain in classic arbitration proceedings, as you all know. But we are heading to a place that we will use for the transaction that actually conduct in the blockchain environment. But now we don't have anything what will happen then. There are some solutions for that. One is the commercial transaction in blockchain, multi-signature wallets. What is that? You have a key for the buyer and the seller, and you establish a third key for the arbitrator in case it needed. But the problem, you have an arbitrator in the blockchain environment, but you don't know who, and the more you stake a coin, a Bitcoin it might be, and another token it might be, you are more closing to be an arbitrator in the blockchain environment. And this is also something you need to think of it, I believe. So we can maybe mention the other smart contracts in the following.
Yeah. So going from, you have just very rightly put, given us the idea of what these technologies are. So
May I just add one or 2 points
Sure.
to what he has already stated? I think one of the important reasons for using the platform, which he has said, the case management platform, which it also comprises of, say, an FTP, file transfer protocol systems, is that everything gets uploaded, automatic messages get sent to the arbitrators and the parties. One is that the emails are not hacked in, but also the data transfers. When you are serving the other party with 6 bundles of documents, the large data that is being transmitted, you always have challenges in transmitting from one person to the other. You will break it up into 20 files and send it, which is inefficient and causes more problems. But also the issue is one of cyber security. I think given the fact that hacking is so simple and possible today, I think having an FTP server or a case management platform makes it easier and protects you from the cyber attacks far more than sending emails across. And there has been a case, I think it was in Brazil, where the opposite party, because of these receipt of different emails and all, they could manage to hack into the opposite side's servers and actually got several confidential data. They could hack in and get the data. But if you create a separate FTP server where you're just uploading what you need to, at least your own servers are protected. And this is a real case in an arbitration. Of course, it became a big issue, criminal proceedings started and everything, but this is not impossible. And law firms are a huge potential for hacking. You know, every minute somebody is trying to hack into one of the law firm's servers. So I think cyber security is so important. The previous session and the sessions in the morning were all about cyber security, protection of data. So I think that also becomes very important for using technology.
So, Pallavi, as you rightly put it, my next question was about, advantages and disadvantages of all
Right.
these techniques and procedures. So, if you can just continue and elaborate.
I'll just elaborate a little more.
Yeah.
I think the first thing in international arbitrations, when you have arbitrators from 3 different jurisdictions, let me put it this way, and parties from maybe 2 other jurisdictions, truly international arbitrations, getting all of them together in one place to find the time, and match the calendars is really, really difficult. Sometimes you don't get hearings for 3 months, 4 months, 5 months because somebody's schedule is blocked. If you're doing virtual hearings, it's far easier to match calendars and get everybody on a Zoom call or a Teams call or whatever way, whichever platform you are using. Makes it very simple to get. Maybe the hearing is just a 2-hour hearing. You don't need to travel. 20 people don't need to travel for 2 hours. I think, as we've just said, there's far more efficient use of technology. If you're going to use e-discovery or a software which I have used in an arbitration in the US, is that you make your submissions, you embed the relevant clause. There are software available for embedding the relevant clauses from the documents itself into the arbitration, and it's the software that picks up the relevant clause, and it's so much faster, so good. Of course, it will mean that you have a technology person sitting in the arbitration room as well. I think logistic flexibility, 20 people don't have to don't have to travel. Also, it's a carbon footprint saving. It's a green approach to everything. When all of us have a carbon footprint, and if 20 of us are not traveling for a 3-hour hearing, I think there's a lot of carbon footprint that is being saved. Also, arbitrators and studies have found that when you are doing on a screen, the hearings tend to be shorter and far more focused. Far more focused. Because there is screen fatigue that sets in at some point. So before the screen fatigue sets in, you want to finish that point that you are making, and you will make far crisper points than rather rambling and going on. Also, the big criticism is, well, I can't see the witness if it's a cross-examination, and can I see the witness's face, what his body language is he alone in the room? But there are techniques for dealing with all of that. And if the camera is close enough to the witness, actually you will see the witness's face, his expressions and body language far better than if you were sitting in a room actually and may just miss it in a fleeting glance. So these are some of the advantages. I think there are challenges as well. It's not to say that there are no challenges. I think when you are from different jurisdictions, different time zones, also finding that right time when all of you can meet is a challenge. Some of us will have to do the hearing at midnight and beyond or through the night, but that becomes inevitable. I think if you are a senior counsel in India, it's very popular to have a senior counsel argue, or somebody who's arguing even from within the firm. If you are sitting in different locations, conferring with your senior counsel or the arguing partner in the firm becomes a challenge if you're not all sitting in one place. When you're in a room, you can brief the counsel, you know, what you need to say, this is the nuance that it is. So that becomes difficult to converse. The client is sitting in another place, so client trying to give instructions, you trying to convey to your arguing partner or counsel, it's a bit challenging certainly. Confidentiality concerns, are you going to send this by mail? What happens if the platform that you use, you're doing something in the Caribbean, for example, and you don't have certain platforms available there, your internet is very slow, how will you manage? So there are a few challenges on technology itself, but nothing that cannot be overcome by planning it in advance. So each of these institutions now not only sort of amended their laws in 2020 when pandemic came, all permitting virtual hearings, whether it was the ICC or the Hong Kong International Center, the Vienna International Arbitration Center, or the Seoul Protocol, all of them sort of amended and got in line, including all the arbitration centers in the GCC. They're very up to date with all of that. Then came the whole realizing that if you use technology, different people use different technologies. So for example, ICC tied up with Microsoft Teams. Somebody, IDRC tied up with Opus 2. Somebody else tied up with another system, Zoom. So different institutions have tied up and they recommend to use that because their own systems are favorable to that. SEAC also has its own. So if you want to do, what you can do is to ask for the services of that institution if it's an institutional arbitration. Alternatively, you can follow the protocols that have been set up. For example, there is the Seoul Protocol on the use of technology and the minimum requirements of technology. So you can follow that and they will tell you how to proceed before. What sort of planning will you do? What will you exchange? How will you do the dry runs? It's all now sort of codified as guidance. So there is enough and more assistance that is already available either from the institutions or from these protocol and guidance, which will help you to navigate this whole process of virtual hearings, how do you get into virtual meeting rooms,
Right.
you know, all of that is now possible.
Possible, yeah. So, Asaf, coming back to you, and while you were talking about blockchain technology and information technology, so can you elaborate upon how blockchain technology emerged, and could you give some reflection on how blockchain technologies have been used in procedures, in arbitration procedures? And related to that, maybe you can also tell us that what are the challenges in these technologies and how can you enforce the awards, you know, in a metaverse environment? How can those awards be enforced?
That's a great question and a tough one. Thank you. Firstly, how you can use blockchain is the most interesting usage is I heard from Ambrose Asko from Carius Law School in Hamburg. He had a project indicating that the arbitration actually used in the blockchain environment. As I mentioned before, the multi-signature wallets, generally in the blockchain environment, you don't know the users because anonymity is the essence of the blockchain. So the transaction is a basic one. You sell if you want to sell a good, it's generally in illegal goods they are selling there. In the black market, you tell them you want to sell this good, and then the buyer want to pay for it with the tokens, and generally they send it to an administrator. So there's a third party in here. An administrator is at the same time both executed the process, and if a dispute occurs, then they also arbitrate and look for a solution between the buyer and seller. But this is something you need to think about, that what if the goods are not met with the conditions that you're looking for, or what if the buyer or the seller has not the capacity to conclude this agreement, because you don't know, you have no idea who it is before you. So in that point, you are coming back to classic arbitration, that you need a third party, who is not an administrator or who is not a party that is not executing the contract. As I mentioned, the crowd arbitration may solve it, but it comes with some challenges. First of all, the cybersecurity, which you already mentioned, and data privacy issue. As we come to data privacy, I guess you all know the great poem Homeros's Odyssey. It says, and they are really using the data odyssey term these days, because data is circulating everywhere in the blockchain environment as well. So when you are using arbitral proceedings in the blockchain, it is inevitable that this data will be transferred cross-border. And you should consider those data breaches and privacy concerns. And if a dispute occurs, the data providers should comply with GDPR Article 32. As you all know, Article 32 provides a general overview for the data providers, and they need to comply with this rule. As far as I'm aware, the GCC countries has similar provisions, but not the exact one. So you can use, for that, you can use cyber security guidelines. As Mrs. Pallavi just mentioned, there's a civil protocol, which is really famous, but other than that, you can use IBA cyber security guidelines, maybe, and 2020 ICCA, the New York Bar Association's CPR cybersecurity protocol, is also really comprehensive one. I can say the most comprehensive one is that as well. Regarding the executable awards, I have an arbitral award, which arbitration proceedings was held in Switzerland in 2016. It's done in 1 year, but I'm trying to now enforce it, and I apply for the first instance court. It's done, and now it's at the appeal session, and we are 23, right?
Yep.
Yeah.
So my plan is, and the firm, the other side, is not exist anymore. So my plan is just take the award and put it in a frame, and then put it in my office, and I can do nothing else. So that's why we need to think about it. And as you all know, the driving factor behind the success of international arbitration and its executability is New York Convention. And with the evolving technology, the concerns over the convention indicates that the convention may not survive with the test of technology. And one challenge with regard to convention is, as you all know, Article 2 of the New York Convention states an form requirement. And it doesn't say anything about the form, so you are assuming it should be in writing. The award should be in writing, but if it's in a blockchain environment, then you don't have any written executable award or any written agreement even. So you are also facing a problem with the intent of the parties. How will you manage this? The maybe suggestion can be that, as you all know, there is in New York Convention there is a more favorable rule, and you can choose as parties. This is my more favorable rule than the other national ones, and I recommend that Unistral Model Law on Electronic Commerce and Electronic Communication Convention, which is still United Nations Convention, as maybe you can choose it as a more favorable rule, and then you can avoid the enforceability issue. But I'm not believing what I'm saying now totally, because it's hard to choose these model laws, I believe. Yeah.
Yeah. So I think we have covered all the parts, and just to your concluding remarks on whether what is the future of this technology? Will the technology take over, or there would be the human element will always be there, and we'll always look up to the human element in arbitration procedures? Both. I throw this question to both of you.
My personal belief is that use of technology is going to increase, not decrease, and the earlier we accept that fact and adapt to technology and adopt technology, the better it will be for all of us. Will it replace the human, the lawyer? I don't think it's going to replace the lawyer. It's a tool for efficiency, cost management, and speed of doing everything, making our lives easier.
Yeah.
But what the human mind brings, like the experience that it has and the interpretation value, I don't think we are all there yet in terms of the use of AI, even generative AI. We are still a long way away. Everybody's on ChatGPT, so am I. But when I see the results, every time I pose the question, I get a different result. So I'm very sort of careful about using it. We will all use it at some point, but I don't think it's going to replace the human lawyer.
I completely agree with you on that, and maybe your thoughts on Asaf.
Because we are running out of time, I also totally agree with what Ms. Pallavi says. Maybe I can reflect on just one point, because the session that held earlier yesterday, I believe, the attendees once say that I more believe in human interaction in those kind of proceedings. I agree, but I think we don't need to fight with these technologies instead of just using it, because even in the end, before our session, the attendees told that AI is learning from human, luckily for now. But because of that, we are trying to let him do his job and enjoy what he is capable of, I believe.
Right. And just to add to it, every case is a unique case. Correct. And it has to be the procedures, and it has to be all the outcome has to be decided in that manner also. So with that, we conclude this session, and I open the floor for the questions, if anybody has any questions. Yeah, so no questions?
That informative, that's great.
I guess we have certain questions here on your left. On your left, this is Sagar. Yeah, we have a lot of virtual participants joining us for the session, close to a good number. So we have a lot of questions, but I guess we should ask this one, which is, what are the ethical considerations and safeguards that need to be addressed when adopting technology-driven dispute resolution procedures on an international scale? So if we can address that.
I think a couple of questions that have arisen. Number one is particularly when you are using AI, the whole concept that we were hearing in previous sessions in the other hall as well is whose IP is it that we are using. But that doesn't arise so much here. It's more the question of due process. Is everybody being given adequate chance and opportunity to present their case? Is it being fair and just to them? The due process is a bigger concern, and that arises not from really, but also from the enforcement purposes. Will somebody take up the thing that I got half an hour, it was on a video conference, and I tell you, this is not a bizarre challenge. I faced a challenge where about 8 to 10 years ago, the arbitrators, one in India, one in the US, one somewhere else, all decided to get on a phone call to fix the schedule of the arbitration and communicate to the parties. The other side challenges, government organization actually challenged it to say they didn't meet physically. And that is prejudicial to me because I couldn't put forth my case, even on a schedule. So these challenges are for real. And if it's an ad hoc arbitration, not an institutional arbitration, some of these challenges do happen. It's not so unusual or bizarre. Therefore, the due process is a bigger issue, if at all, rather than just the ethical issues to it.
Hello. Yeah, that was helpful, ma'am. Thank you very much.
Thank you.
Big round of applause for the panel and for the virtual participants as well who are with us. I'm really sorry, we have one more question.
Sagar, thanks. Ma'am, I hope I'm audible. Just wanted to ask you from the point of view of somebody who practices and does some arbitration work, where do you see the challenge in terms of this whole jurisprudence when it comes through in terms of challenges on the seat question? Now, say for example, we have online arbitrators joining from different places, the seat is determined. Of course, the venue is varying in multiple places, but where do you think ultimately when it comes to these kind of challenges, will this create further blocks in terms of enforcement of arbitral awards, especially when it comes to executing an arbitral award? At the end of the day, the challenge is to get it executed in a place of jurisdiction and in a proper place of jurisdiction. And do you think or do you foresee online arbitrations essentially running into a roadblock when it comes to ultimately monetizing these awards for, or getting them enforced in the long run? How do you see that panning out?
So to the answer to the first question on the seat and therefore the enforcement and all, I think there are two different issues. One is the seat of the arbitration. The parties can agree to what is the seat of the arbitration and then also hold the hearings virtually. In fact, once you determine the seat of the arbitration, either it's in the contract or at the time of the hearing itself, you can determine the seat of the arbitration. Or if parties don't agree, the tribunal can determine the seat of the arbitration. And then whatever award is passed is deemed to have been passed at the seat of the arbitration. Because quite often in today's day and age, you will see 3 different arbitrators signing the award in 3 different jurisdictions and issuing the award. So that doesn't mean the award is not issued at the place or the seat of the arbitration. So that's one thing. Venue is different from seat, and so the venue can be one of convenience. Same way, a virtual hearing can be a matter of convenience if you wanted to. So I don't think the challenge and second is where will you challenge the award? That you will of course challenge it at the seat of the arbitration to begin with, unless you want to come for an enforcement. If it was India, and then raise the grounds that may be available under 48, since we are only looking at international arbitrations. So both are distinct and both I don't think pose a real problem.
Thank you, ma'am. Thanks.
Thank you.